try and educate some processes. I was going to go if perhaps we have an opportunity to discuss this week. So I'm not going to go to the I have read the letter, I've read this books. What concerns me is this is an MCA who is a party who is making allegations against the judiciary and the judge that he had not removed. This is not no disrespect to this matter, but in other matters perhaps those council, those parties would say our matters are more high profile, our matters are billions, trillions, our matters are president, parliament, wide issues. But I understand that for every single litigant, their case is the largest case in the land. I can see enough from what she was posting to say the better way forward for justice, for the judiciary, for the people of Kenya is for me to sit with Madam Zipporah and explain to her why this is not supposed to, why it invites us into violence, why it invites a lack of confidence. So perhaps I'll have that opportunity. Let me make clear, none of what has been posted is remotely true. I have been extremely fair in this matter. I have tried, okay, let me say I've tried my best. You will have to tell me whether I have been extremely fair. I want to make it absolutely clear, that allegation of brown envelope, no. I can say this because the High Court can only speak through judgments and rulings. It can only speak also in open court. There's an ongoing discussion. Councillor Ngoya has referenced a phrase that has become, colloquially speaking, toxic. Jurisprudence. We should not let this be the excuse for every negative outcome that a litigant suffers, to accuse the judge, magistrate, Kadhi, tribunal member of corruption. I was in private practice. I lost cases. I went home, I was sad. I lost cases that I felt very, very strongly the judge or magistrate had gotten it wrong, but not corruption. Corruption is such a serious accusation that it should not be made on the cuff. It should not become the regular discourse of our country, but it has. Ordinarily then, contempt of court. But my primary duty as a judge is to maintain public confidence in the judiciary, in all that I do, And while I'll not mince my words, it hurts to see someone accusing you of things that are not true. But I will not hold it against her. I understand that we have gone in a particular direction, and each one of us as judges, magistrates, Kadhis, tribunal members, it is our duty to keep our heads held up high, to continue showing the Kenyan people why what is being said about this institution, us as a college of judges, magistrates, Kadhis, and tribunal members, is not true. So when you have an opportunity, counsel, to speak to your client, pass this message on to her. For better or for worse, I will determine this matter based on the law. My understanding of how that law applies to the facts. I am bound by courts above. I am bound by previous decisions. I was only appointed in May of last year. I don't think this is it for me. I will want one day to go to a higher level. And I can say right now, this may be one of the cases that I will cite. And that is a protection that perhaps the people of Kenya don't understand. We are always accountable for our decisions. 5 years, 10 years, 15, 20, even after our deaths, we have to explain why we did things. And I will always do, when I'm in this chair, for as long as I'm in this chair, I will always do something that I can explain, I can live with, and something I'll be proud of. So tell your client, in as much as what she has done is reprehensible, I would rather, when we are next in court, before I read the judgment, just have a little discussion with her so that she can be a brand ambassador for the judiciary and say the judiciary is being accused falsely, wrongly, and we can put this issue to bed. Counsel Ongoya?
I can do that. My client has had it. I think.
Thank you. Mr. Muriuki? Counsel Muriuki?
Yes, Your Lordship, just again, for the record, we completely dissociate with whatever the client has said. And
Yes.
on the day of judgment, we'll endeavor to bring her here.
Which day of judgment? You know, there are 2 days of judgment. Yeah. I hope you mean the judgment date, not the date of judgment.
The earthly judgment for this matter.
Okay. Yes.
I am extremely impressed by his conduct on this particular issue. Because
Yes.
his conduct,
Yes.
he apologized very upset.
Yes.
Professionally speaking, that's something we take very kindly because that's the way this profession is designed to be. That a client will be able to, an advocate will be able to where the client has brought the line. And from the very outset, we don't become controversial about it. And I think I must put on the record that Mr. Muluka has become extremely maturely as
Yes.
a professional on this particular issue. We commend him for that.
Yes, that is true. The court also thanks you, Counsel Muriuki, for that. Just speak to your client, and before the judgment, we'll take about 2-3 minutes, and I'll try and be a brand ambassador and make her a brand ambassador for the judiciary. So we were coming for highlighting for those opposed. We started a little bit late because I was told that not all counsel had arrived. Have you agreed on how much time you'll take?
Yes, my lord, on behalf of the parties opposing the petition, you had given us 3 hours.
Yes.
We are comfortable to share it out between ourselves.
Yes.
Mr. Mukele taking 1 hour. My lord, we are requesting that the county assembly comes in next 45 minutes. And then between the other, so 1 hour, sorry. Then the other 30 minutes we'll share with Mr. Muriuki and myself. And the speaker.
So that will be 3 hours. We will begin at approximately 1 o'clock. We will do the 3 hours. Please bear with us. We'll do the 3 hours continuous. That will take us to 4 o'clock. Then we'll take a brief health break, maybe 20 minutes or so. Counsel Ongoya, rejoinder 45 minutes, 30 minutes?
45 minutes.
45 minutes. So God willing, we'll be done by around 5:15, 5:30. But as I said on Friday, I am here as long as you require me. So, Counsel Mukele?
Thank you, Your Lordship.
Just a moment of the time I'm supposed to. So the rules remain the same. If I interject, ask a question, your time will stop. So, Counsel, you can begin now.
Thank you, Your Lordship. First, I would just like to join Counsel Muriuki in
Yes.
apologizing to this court for what has happened. It is highly regrettable, Your Lordship.
Yes.
So, as I proceed further, Your Lordship, for the respondent, Your Lordship, we have filed the following documents. One is a reply affidavit sworn by Mr. Jeremiah Nyegenya, who is the clerk of the Senate, on 21st of August 2024.
Yes.
We also have a further affidavit sworn by the said Mr. Jeremiah Nyegenya on 24th of January 2025. We also have our submissions and list and bundle of authorities dated 11th February of 2025.
Yes.
Your Lordship, from the submissions, I have crystallized the following issues for determination by this Honorable Court.
Yes.
Yes, Your Lordship, the first issue is whether the Senate actions concerning the impeachment of the Governor of Meru adhere to the legal requirements established in law.
Yes.
The second issue is whether the proceedings of the Senate, before the Senate, for the hearing of the impeachment charges was sub judice.
Yes.
The third issue is about the probative value of the evidence adduced by the Governor.
Yes.
The next issue, Your Lordship, is whether the impeachment of the Governor was done in defiance of a valid court order.
Yes.
Followed by the issue of the constitutionality, sorry, Your Lordship, of Section 33(8) of the County Governments Act.
Yes.
Then I have an issue as to whether the particulars of the allegations against the Governor were substantiated.
Yes.
And lastly, whether the orders sought by the petitioner can issue against the respondent.
So before you begin, let me just hold your time. Is the second sub judice? This would be sub judice, you'd be referencing ELRC matters.
No, sub judice with regard to consideration of the Senate, which was the allegation that we considered matters that were before court.
Would that be our sister court, the ELRC, or the Meru High Court?
Your Lordship, it's the Meru High Court.
May I propose then that you canvass sub judice number 2 with number 4, the valid court order, because they would tie.
Okay. Yes, Your Lordship, I will measure out the issues.
Okay.
I will not go into in-depth in all of them.
Yes.
Try and save the court's time.
Okay, so your time is back on.
Thank you, Your Lordship. So, Your Lordship, to begin with issue 1, for proper flow, Your Lordship, I want to start with the issue of whether these orders, the orders sought in this petition, can issue against the respondent, Your Lordship. Your Lordship, when I sat here on Friday, and you raised the issue about the valid court order, you gave parties a chance to respond, Your Lordship.
Yes.
The petitioner raised certain issues about that order. The interested party also had a chance to raise those issues, Your Lordship. But I sat here as counsel for the respondent, who's the Speaker of the Senate.
Yes.
And Your Lordship, I could not answer to those issues that were being raised, Your Lordship. And I asked myself, so what exactly is the respondent doing here, Your Lordship? Your Lordship, the Speaker, the respondent is the Speaker of the Senate, no doubt.
Yes.
And the role of the Speaker of the Senate is outlined under Article 122, 2A of the Constitution, which specifically states
Yes.
that the Speaker has no vote on a question proposed in a decision of either House, Your Lordship. So then, Your Lordship, I asked myself, what is the Speaker doing in this matter? Your Lordship, I am aware that Rule 5B of the Mutunga Rules provides that a petition shall not solely be defeated by reason of misjoinder. I am aware to that fact, Your Lordship. But Your Lordship, is this a blank check to just sue anybody, Your Lordship? Where is the voice of the Senate in this matter, Your Lordship? Your Lordship, in fact, it was just by good fortunes that the County Assembly was joined in this matter as an interested party, Your Lordship. Otherwise, we would never have had the voice of the County Assembly equally in this matter, Your Lordship.
Yes.
So then, Your Lordship, where is the position of fair hearing in this matter? More so, Your Lordship, because if you look at the amended petition, a huge chunk of the remedies or relief sought
Yes.
are against the Senate, Your Lordship. Particularly, Your Lordship, I'll make reference to the amended petition by the petitioner. And I will point out, Your Lordship, order D, E, F, H, and I. Your Lordship, I would have verbatim read the orders, but maybe I'll just choose one.
Yes.
Your Lordship, there's an order here of a declaration, which is F of the reliefs in the amended petition.
Yes.
They are seeking an order that the respondents' impugned resolution made on 21st August 2024 was founded on grounds that lacked the legally established threshold for removal of a governor by way of impeachment, Your Lordship. Your Lordship, the respondent is the Speaker of the Senate. Which resolution did the respondent make, Your Lordship? Similarly, Your Lordship, and to be a bit more explicit, there is prayer H, which is a declaration that the Senate, in its evaluation and impeachment of the impeachment proceedings before it, failed to properly assess each of the specified grounds, and then it goes on like that, Your Lordship. Where is the Senate? Your Lordship, is it proper, even though we have that the order on Mutunga rules, is it proper, Your Lordship, for purposes of fair hearing, is it proper?
Yes.
Your Lordship, our submission, or the respondent's submission, Your Lordship, is that one, the Speaker is not the proper party in this suit, Your Lordship. And I think we tried to canvass this during the preliminary stages, Your Lordship, but you reserved the same for the final hearing, and here we are. And secondly, Your Lordship, that these orders, specifically those I have pointed out, cannot issue against the respondent, Your Lordship.
Yes.
Your Lordship, I'm also looking at prayer E,
Yes.
which is a declaration that the respondent's decision to uphold the resolution of the County Assembly of Meru leading to the removal of the petitioner from office by way of impeachment was unconstitutional and a violation of the petitioner's entitlement, and so forth, Your Lordship. Your Lordship, a petition cannot be an avenue to sue parties who, to say the least, are not the right parties, Your Lordship. But because a petition cannot be defeated by reason of misjoinder or unjoinder, Your Lordship, you rely on that provision and you seek adverse orders against parties who are not here, Your Lordship. Lordship, I'll say no more about that issue. I will move next to whether the Senate actions concerning the impeachment of the governor of Meru adhere to the legal requirements, Your Lordship.
Yes.
Your Lordship, from paragraph 7 through to 32, I have set out a chronology of events, Your Lordship, outlining the process before the Senate from the time of receipt of the letter all the way to the hearings, the ultimate impeachment,
Yes.
and the Gazette notice, Your Lordship. So the question, I have put sub-issues under that heading, Your Lordship. So the first issue is whether the petitioner was accorded, sub-issue, let me call it sub-issue, whether the petitioner was accorded a fair hearing before the Senate, Your Lordship. The Supreme Court quotes the Union of India, or rather Justice Njoki Ndung'u quotes the Supreme Court, the Union of India case versus J.N. Sinha, which in essence, Your Lordship, just to summarize, observed that with regards to fair hearing, Your Lordship, each case has to be decided on its own merits, Your Lordship. So there's no blanket application of the fair hearing, Your Lordship. So, Your Lordship, with regard to the actions of the Senate, how did we observe fair hearing, Your Lordship? I have recited this from paragraph 36 of my submissions, Your Lordship.
Yes.
We issued invitations to parties, Your Lordship.
Yes.
We facilitated exchange of documents by the parties, Your Lordship. Your
Yes.
Lordship, we convened the plenary to hear the case, Your Lordship.
Yes.
We allowed parties to be represented by counsel, Your Lordship. Timing was also given for the hearing of the case. Parties were allocated the time.
Yes.
Your Lordship, parties were also allowed to raise any preliminary issues prior to commencement of this hearing, Your Lordship. Your Lordship, parties made opening statements, both from the Assembly and the Governor.
Yes.
Parties called witnesses to give testimony. This evidence was led in chief. The evidence was cross-examined.
Yes.
And equally, Your Lordship, there was re-examination, Your Lordship. And Your Lordship, further, senators were allowed to seek any clarification or ask questions to the witnesses who were present, Your Lordship. And finally, Your Lordship, or not finally, parties gave their closing statements, Your Lordship. And then, Your Lordship, equally, the Governor was called upon to make her closing remarks.
Yes.
Your Lordship, what I have read to you is step-by-step account of the rules of the Senate.
Just a moment before, let me stop your time. Before we leave that point, did the governor indeed make her closing remarks?
No, she didn't, Your Lordship. But she was called upon to make her closing remarks, Your Lordship. So when that opportunity is availed to you, Your Lordship, you take it.
The videos, I didn't watch the videos in court. Why didn't the petitioner make her closing remarks?
From our side, Your Lordship,
Yes.
the opportunity was availed to the petitioner. And the speaker actually paused and waited for the petitioner to make her closing remarks, Your Lordship.
Does the affidavit, the second affidavit by the clerk, canvass that issue?
Your Lordship, this is captured in the first affidavit.
The first affidavit?
Yes. And perhaps because, Your Lordship, I would have to refer you to, we annexed the Hansard for both these, Your Lordship.
Yes.
In our affidavit.
Yes.
And particularly, if you look at the proceedings of the Hansard,
Yes.
on the second day, Your Lordship, that is 20th of August 2024.
Yes.
For quick reference, I'm using the Assembly's documents because I can see the Hansard here.
Yes, the reason we are pausing
Yes.
is because much was made by the petitioner about that Hansard and about some of the notations and marginal, let me call them marginal notes. So your time is not running. I just want us to, for the clarity of the record, what the speaker allocates the opportunity, what then happens?
Your Lordship, perhaps I could just read verbatim.
Yes, please.
Yes, Your Lordship, here's what happened. So the speaker, this is August 20th, 2024. The speaker goes, I'm looking at, for easy reference, I'm looking at, oh, this is page 142 of the proceedings of 20th August 2022.
Yes.
Yes, Your Lordship, just read verbatim. The speaker goes, very well. At this juncture, I will call upon the Governor of Meru County in 2 minutes to make her closing remarks to the Senate. Proceed, the Governor of Meru County. If you have anything to say, this is the time to address the Senate. If you do not have anything to say, it is okay. Your Lordship, that, I don't know how clearer it can be of being given an opportunity to make your comments, Your Lordship.
From the Hansard, what happens?
Yes, Your Lordship, what happens after that is, and you'll see perhaps, Your Lordship, from the record, then the next event, because the
Okay, let me clarify.
Yes.
There's reference there to Sergeant at Arms. The court cannot assume it knows what was going on. So what is your understanding of why the respondent then calls upon the Sergeant of Arms?
Your Lordship,
Sergeant at Arms, sorry, Sergeant at Arms.
Your Lordship, the calling to the Sergeant at Arms is to ring the bell, Your Lordship. That's what I'm looking at from the answers.
Just read it.
Okay. It says, clerk, you may ring the division bell for 2 minutes.
Yes.
Then is the sergeant at arms ringing the bell? Sergeant at arms, proceed to lock the door and draw the bolt.
Okay.
Yes. And then, honorable senators, kindly take your seat. We will proceed to vote.
Okay.
Yes.
All right. So there was an assertion that there was disorder which then prevented the petitioner from speaking. Does it occur on that page?
I do not see the disorder, at least to the extent that the petitioner talks about.
Yes.
The speaker here, at the same page, 143, he says order. And in the Lordship, naturally by the proceedings of the Senate, the speaker's role is to regulate the debate, is to call the House to order, Your Lordship.
Yes.
So then, when you say there was, as the word they use, grave disorder, Your Lordship, which grave disorder is this that is being described? For instance, Your Lordship, I remember one incident, just let me confirm.
Am I going to talk about it 142 or 136?
142.
But the house that you want to stand by the editor is that there was a standard advantages.
Yes, the one I'm referring to from...
Because the standing by the answer, we are charged to be able to get about 136. So I was thinking that so that the contract was clear.
Okay, so that's 136, Your Lordship. In this is page 142.
Did you download yours from their website?
Yes, let me just my. Your Lordship, I'm told it is the same document on the website. Though I'm trying to locate mine in my affidavit.
Or perhaps you can use the petitioners.
So that will be volume 1 and page 358.
That's fine, Your Lordship. We can use if it's the same document, we can use that.
So on the volume 1A, page 358, it runs into 359.
Correct. I've been happy as my colleague talk about the comments of the majority that I have.
So on page 358, I'll begin with the Speaker addressing the Governor. Very well, at this juncture, I will call upon the Governor for Meru County in 2 minutes to make her closing remarks to the Senate. Proceed, Governor for Meru. If you have anything to say, this is the time to address the Senate. You do not have anything to say, it is okay. So let the mover of the motion proceed to reply.
Your Lordship, and I think that's the point I had mentioned earlier. The opportunity is a great for the government. And remember, Your Lordship, the Speaker had said, if you have nothing to say, it is okay, Your Lordship. So
Why isn't the petitioner then recorded as saying that?
Your Lordship, she was seated. She sat down even as this comment was made. She never, and we had a podium, Your Lordship. She never came to the podium.
So let's go down to the bottom. I want us to all be on the same page on 358 as much as possible in an adversarial system. It's the Senate Majority Leader, into brackets, Senator Cheriot. Mr. Speaker, sir, in light of the fact that there are people who've chosen to behave in a disorderly manner, I cannot give my comments. I beg to reply. What is going on there?
Your Lordship, there was, and I've considered this, Your Lordship. There was commotion in the Parliament. I've not denied that, Your Lordship. But the role of the Speaker, Your Lordship, is to call parties to order. And Your Lordship fully understands the nature of parliamentary proceedings, even the Senate, Your Lordship, and the nature of debate, Your Lordship.
Yes.
The speaker had to call the order, Your Lordship, so that the process can continue, Your Lordship. And Your Lordship, this, and I was about to give an example of when a situation arose that I can refer to as grave disorder, Your Lordship. Your Lordship will remember during the time of the Securities Amendment Bill, Your Lordship.
Yes.
Your Lordship, that now, if I was to use the words of the petitioner, that could be classified as grave disorder, where parties attempt to take the mess, and in every description of circumstance, that becomes a proper disorder in Parliament, Your Lordship.
Okay, just give me a moment.
Yes.
Just give me a moment. Do we have just the segment of that part, nothing else, just this part? So that if there is something that is missing from the Hansard, perhaps it was not captured in the loud consultations, we are able then to see it. Councillor Ongora? I'm only interested.
Yes, but I'm not the link is accessible. My assistant is actually also so I'm getting that's AM7 at minute number 26:48 seconds.
Councillor Mukele,
Yes, Your Lordship.
can we watch minute 26?
Instead of 26:40, we will do see that there's
Yes, 26:40 onwards. Just that part. We will view nothing else, just that part. So your time has been off that entire time. It will continue to be off. You can take your seat while we try and sort that out.
sorry, my lord, but maybe I could have your directions on this.
Yes.
I remember on Friday we had an issue with the playing of the videos. I know this has come from the court, my lord. And Lordship, I think that an issue wasn't the videos as they were.
Yes.
The certificate of electronic evidence as presented by the petitioners.
Yes.
And my lord, at the moment I see the petitioners want to play a video from one of their documents. My lord, for veracity and identification purposes,
Yes.
I think we could have a better direction of this so that we don't then watch a video that we cannot verify or accepted or admitted as part of the evidence of the petition.
What I would like to do at the highlighting stage is offer counsel for the respondent an opportunity before I retire to write the judgment to characterize what is going on. And that is all I am limiting myself to. It is about 47 seconds long. So I know exactly what is said. I just want us to do it for the record. Nothing else. None of the 26 minutes before, none of the almost 20 minutes afterwards. Just that roughly 46 seconds.
Thank you, my lord, for that clarity. We are happy to have
If it's not possible, now we can move on, and then when it's technically possible. Nema, are we far off?
You can just proceed.
Okay. So council, yes. So your time is back on.
Okay, thank you, Your Lordship. Your Lordship, in any case, I
Yes.
submit that there's no requirement in the law
Yes.
that the governor must address, and I use must, the
Yes.
Senate prior to the voting of the impeachment charges, Your Lordship, sorry. Your Lordship, if you look at Section 33(6) of the Ghana County Governments Act,
Yes.
and the same is mirrored in Standing Order 84 and 80
And it's mirrored in
standing orders, Senate standing orders, Your Lordship,
yes.
84 and 85.
Yes.
The said section just states that the Senate shall, after according the governor an opportunity to be heard, vote on the charges, Your Lordship. Equally, Your Lordship,
Yes.
Understanding Order 66(1) of the Senate Standing Orders, it provides for the manner of debating of motions, Your Lordship.
Yes.
Your Lordship, the said section provides that when a motion has been moved and if necessary seconded, the Speaker shall propose the question thereon in the same terms as the motion, and the debate, Your Lordship, may then take place upon that question, Your Lordship. So, Your Lordship, unless you are pointed to a specific requirement
Yes.
that says says the governor must have made the comments, Your Lordship, then there's no basis for the same, Your Lordship. Our submission, Your Lordship, is that the governor was given an opportunity to make her comments. Your Lordship, she did not do that, and the Speaker proceeded, Your Lordship.
Yes.
And in that regard, Your Lordship, even that opportunity to be heard, Your Lordship, and this is our submission, should be looked at from the entirety of the proceedings, Your Lordship.
Are you sure you want to say that so that we watch the whole proceedings?
Yes.
In that regard, even the opportunity to be heard should be looked at in light of the entire proceedings.
Yes. Your Lordship, the opportunity to be heard before the Senate should be looked at in its entirety, Your Lordship. From the invitation.
So just very briefly,
Yeah.
so your time is off.
Yes.
There are other sources aside from the Google Drive links that the petitioners have forwarded. Those were televised proceedings. They are on other channels. Should then the judge watch the entire proceeding?
Your Lordship, I honestly cannot stop the court from watching the proceedings. In fact, Your Lordship, that is at your sole discretion. Because we will make submissions, they will make submissions, Your Lordship. But ultimately, you will have the final say. So I will make my submissions, they will make theirs, and you will have the final say, Your Lordship. I can't stop you from
So
watching
at the end of this, just before we break for the day and I reserve the matter for judgment, we'll pick up from where Counsel Kirimi invited me, and I will give directions on it so that it is very clear, so that I'm not going behind anyone's back and watching things. If we are unable to agree that I should then go and watch, then I will not watch, I'll just rely on the answer. Okay, so have we gotten to that part? Councillor Ondoya, please give us the timestamp.
For my comment, it was 26:48. I think that's 26:40. Yes, 26:40.
case, I will not say anything because under the circumstances, I can't express myself.
Very well. At this juncture, I will call upon the Governor of Meru in 2 minutes to make her closing remarks to the Senate. Proceed. Governor of Meru, if you have anything to say, this is the time to address the Senate. And Governor of Meru, if you don't have anything to say, it's okay. So let the mover of the motion proceed to reply.
Okay, that's enough. In that regard, even the opportunity to be heard should be looked at in light of the entire proceedings.
Entire proceedings, Your Lordship.
Yes.
And as Your Lordship, I don't know if I should comment about this, but as I've seen,
You can. I'll switch off your time.
Your Lordship, the Speaker sits there and actually waits and looks at the Governor, Your Lordship. There is actual time given waiting for the Governor, Your Lordship. You've been told of chaos, you've been told of Your Lordship, I have, at least from my end, I have not seen the chaos that was so bad that the Governor could not make those remarks, Your Lordship. Where is the evidence?
Yes.
Yes, Your Lordship. I have already submitted on the fact that opportunity to be heard should be looked at wholesome, including the fact that Council Longoya, Senior, was given a chance to make the closing submissions, Your Lordship. He cross-examined at length, Your Lordship, the witnesses. Senators asked questions and clarifications on those issues, Your Lordship. So, my submission is that the Governor was accorded a fair hearing before the Senate, Your Lordship. And contrary to the allegations or assertion that there was grave disorder, Your Lordship, that video and other videos, Your Lordship, and you're free to watch them, will show otherwise, Your Lordship. I think we all understand what grave disorder means, Your Lordship.
Yes.
Your Lordship, next, I will move to the issue of limitation on debate on the motion. That's a sub-issue.
Yes.
Your Lordship, limitation of debate is provided for understanding order number 113 of the Senate Standing Orders, Your Lordship.
Yes.
So, Your Lordship, Senator Gerard Gay moved a motion for the limitation of debate, Your Lordship. And
Yes.
that was limiting the debate to 3 minutes, Your Lordship. Your Lordship, when this happened,
Yes.
there were points of order, Your Lordship. And so, Your Lordship, because of that kind of setup, Your Lordship, the 3 minutes that had been given lapsed, Your Lordship. Your Lordship, the limitation of debate is a sovereign function of the Senate, Your Lordship, in its standing orders, Your Lordship. So unless someone seeks to challenge that provision of limitation of debate, Your Lordship, then any other invitation for this court would be, to say the least, unconstitutional, Your Lordship. The rules of procedure have not been challenged in this petition, Your Lordship.
Yes.
In any case, Your Lordship, our submission is that debate, as the petitioner alleges, is not mandatory, and I think I made reference to this point, Your Lordship. I quoted particularly section 33(6) of the County Government Act. I quoted standing order 84 and 5 of the standing orders, and standing order 66(1) of the standing orders as was demonstrated.
In any case, debate is not.
It is not mandatory.
Yes.
Finally, I referred to standing order 66(1) of the standing orders.
Yes.
But above all, Your Lordship,
You also mentioned section 33.
6 of the County Government Act, Your Lordship.
Yes.
But in any case, Your Lordship, even as our work is to respond, Your Lordship, it is for the petitioner to demonstrate precisely how she was affected by this, Your Lordship.
Yes.
Evidence need to be led to show how she was affected, Your Lordship. And I think this is in line with the Anarita Karimi case, Your Lordship. There needs to be precision. You need to show how this issue about debate affected your rights, Your Lordship.
Yes.
So even if, Your Lordship, you say, as they like to call it, grave disorder, which of course I don't see it as such, then how did this grave disorder affect you, Your Lordship?
Yes.
So our submission on that issue is that debate, limitation of debate motion is recognized under the standing orders, which are made by the Senate, which is the legal entity empowered to create its own rules and procedures, Your Lordship.
Yes.
Now, Your Lordship, I'll move to the next sub-issue, which I think is has been harped on quite a bit, which is that debate occurred on a date not gazetted, Your Lordship.
Yes.
Your Lordship, it is not disputed about the dates on the gazette notice of impeachment. And equally the letter, I think there was a letter that was read here, I just can't find it. It is not disputed, Your Lordship.
So we have a letter from the clerk of the Senate to the County Assembly. It's dated 20th August. We also have a gazette notice of even date communicating a decision, and it is dated 20th of August. That is not in dispute.
That's not it.
Yes, proceed.
Your Lordship, I will make reference to standing order 34(6) of the Senate standing orders, which provides for interruption, or what I think many like to call adjournment.
Yes.
Your Lordship, just a second, I'm trying to 34(6) of the Senate standing orders, yes, Your Lordship. It provides as follows. If at the time appointed for interruption of the business,
Standing order?
34(6), Your Lordship, of the Senate standing orders.
Yes.
It provides that if at the time appointed for the interruption of business, a division is in progress, or a question is being put from the chair,
Yes.
and a division results immediately thereon,
Yes.
such interruption shall be deferred until after the declaration of the numbers and the result of the division election. Now, Your Lordship, at paragraph 62 of my submissions, I have at length referred to the events that happened.
Yes.
And I have also singled out that 2 divisions, Your Lordship, happened during the same time, Your Lordship. One was a division on the proposed motion by Honorable Senator Samson Cherargei. And secondly, Your Lordship, the second division was on the proposed motion for the proposed removal from office by impeachment of the governor, Your Lordship. That was the second motion. Your Lordship, at paragraph 63, I have explained at length what a division means, Your Lordship.
Yes.
But in essence, when a division is called, and remember, Your Lordship, a division is also only called when a question is one that affects counties, Your Lordship.
Yes.
Yes, Your Lordship, 2 divisions in which every senator who forms a single delegation for purposes of voting for that county must vote, Your Lordship.
Yes.
Your Lordship, this exercise is a lengthy one by all standards, Your Lordship. So, Your Lordship, when that division has been called, in fact, that is why the rules recognize that that can take time, Your Lordship. Then, that day that was the last day, which was 20th, Your Lordship, ultimately spills to the 21st, Your Lordship. And not because of any malice or any planning, Your Lordship. It is what the rules provide. These are rules of the Senate, Your Lordship. So ultimately, Your Lordship, is that the hearing extended, yes, admitted, to the other day, Your Lordship.
Yes.
But not out of ill faith, not out of, what is being suggested here, Your Lordship. It is out of the rules, Your Lordship. And remember, Your Lordship, when the Gazette notice was issued,
Just a moment. Let me go back into the amended petition. So let me just stop your time, just to be fair. Going to paragraph 36. My understanding so at paragraph 30, that is mentioned. So the time when voting on the resolution of the Senate of the impeachment motion took place fell on a day that was not gazetted by the Senate for consideration of the impeachment motion following a chaotic session where several members of the Senate protested denial to debate the motion. But then at paragraph 36, I couldn't find that as one of the express pertinent questions of law, as the petitioner was putting it, that the court was being invited to determine. Maybe so that I'm very clear, I don't write something that is not controverted. Councillor Ngoya, is that still, do I still need to give a finding on paragraph 30 of the amended petition? Or was that dropped out because it's not in 36?
The spillover is admitted split off.
Yes.
It lays context for you to, it's not in itself a violation. It lays context for you to ask,
Yes.
why do we have the gazettement of the impeachment of the governor on 20th, which is what we are calling a predetermined decision.
Yes. Council has already conceded
Yes. So
to the dates.
Over here, itself is not pleaded as a violation. It contextualizes for you the subsequent challenge gazette notice that happened on the day from which the proceedings are spilling over.
Okay.
So the fact of spillover itself is not an issue in international law.
All right. So that's clear. Okay, your time is back on.
Your Lordship, I also make reference to the Gazette notice, which is number 124, dated 16th August 2024. Your Lordship, I'm not find where it was, but in essence, it was the Gazette notice, Your Lordship. It is number, yes, 10/123. In essence, it is the Gazette notice that announced or declared the dates for the sittings, Your Lordship. That's just the import of it. The Gazette notice that declared the dates for the sittings. Yes.
Are we talking about the same Gazette notice?
Your Lordship, this is which Gazette notice are you referring to?
Is there a Gazette notice dated 20th August?
Yes, Your Lordship. But there's also another Gazette notice, Your Lordship, dated 16th, and I annexed it to my line of affidavit.
No, let's put aside the one for 16. What I recorded earlier is that you have no issue with this, the letter by the clerk dated 20th August 2024, neither with the Speaker's Gazettement, which is also dated 20th.
Yes.
So there is no issue to that.
There's no issue, Your Lordship.
But the voting took place on 21st.
Your Lordship, for the reasons that I have mentioned, I've just mentioned, that when that division and voting exercise takes place,
Yes.
it is only upon conclusion of business, Your Lordship, that it is taken that day is complete.
So why not just gazette it 21st? Why not date also the letter 21st?
Because, Your Lordship, it is part of the business of that day. It has not terminated.
The petitioner is saying this is proof of a predetermined outcome. So that these letters were sitting in someone's draft folder, if I understood the example that was given, and they were just sent out.
Your Lordship, far from the truth. And for the reasons I've just given you.
Let's go into the affidavit so that let's go into the first affidavit by the clerk. Don't worry, your time is not running.
And remember, Your Lordship, at paragraph 33.
Yes, just read it.
Paragraph 33 of my reply. It says, by way of a Gazette notice dated 20th August 2024 and published on 21st August 2024, Your Lordship.
The publication date is not at issue.
Yes.
Does the clerk, because I want us to be on the same page,
Yes.
does the clerk, your deponent, in that first affidavit where he addresses that issue quite at length, does he give the explanation you're giving me?
Your Lordship, the explanation has been given. It which is from paragraph 46.
Yes, just read it.
That in response to paragraph 29 of the petition, I wish to state that at the time the House was scheduled to adjourn, the Speaker of the Senate had put the question on the charges against the governor and division was in process.
Just a moment. When I read those paragraphs, that paragraph 46 onwards, my understanding was the clerk was trying to explain why the vote continued into 21st, but was not explaining why his letter and the Gazette notice were dated 20th. That is my understanding of those paragraphs. So is there anywhere where, because this is a question of fact, where a deponent, it's the same deponent for both affidavits, says we dated it 20th, not because the decision had been made on 20th, but because of this is how we do things. Is that there?
No, Your Lordship, I'm not seeking any explanation of that.
My Lord, if I may.
Yes.
Perhaps I can provide some context into that. My Lord, besides being an advocate of this court, my Lord.
But now you'd be testifying from the bar, which is what I'm trying to avoid.
My Lord, perhaps I can give some clarity to the court.
Yes.
It is a long-standing parliamentary procedure that any decision of any legislature, leave alone the Senate, is actually captioned and actioned on the day it was made. A long-standing custom, my Lord, you may find it in X's May book, which are on parliamentary customs. Majority actually of parliamentary customs and practices, they are not codified, but they are actually legislative processes that are actually provided in customs of the UK Parliament. The essence is that what my colleague is trying to give context to is that the moment the division bell is rung, you may look from the answer and find that the Speaker orders the Sergeant at Arms to draw the bar. The significance of that means that nobody can leave the chamber, no member can actually enter the chamber, and time freezes. That's the essence. Time freezes, my Lord.
Now,
so in the essence,
yes,
that a division bell is rung, and until that bar is actually drawn back, that the time that is provided there will be captioned on the date that the bar was actually drawn. And in parliamentary custom, my Lord,
yes,
the office of the clerk reports a resolution on the date that resolution was done. For what my learned colleague is...
But the resolution was done on 21st.
No, my Lord. That's where
the voting indicator is, there's a timestamp. The timestamp says it's about 40 something minutes past midnight. It is on 21st.
My Lord, it's what we are bringing. What we say time actually stops is the day that the division bell was rung, which was on 20th. And parliamentary divisions actually can extend even to a whole day, because there are instances whereby a parliament will not adjourn until a decision is made. That decision will be made on the day that the division bell was rung, which was on 20th, my Lord. So any decision that was made by Senate on that day was actually made on the 20th. The office of the clerk...
Just a moment, Counsel. Just a moment, Counsel. I deal with Gazette notices almost daily. And I think as advocates, you also deal with Gazette notices. This seems very, very peculiar, because when we look at letters, it is dated this. That is the date we presume someone wrote it. When you're speaking to an external person who may not understand, especially a Gazette notice, who may not understand the arcane English parliamentary procedures, wouldn't it be better just to date it? And then what evidence do we then have that what the respondent is saying is not correct? Sorry, what the petitioner is saying and what the respondent is now saying from the bar are not correct.
My Lord, I do understand the confusion that is there. For purposes of clarity, my lord, I understand where the court is coming from. For persons who may not actually be proficient in legislative processes, the resolution is customarily dated on the date that decision was made. And that parliamentary day, a parliamentary day, my lord, is different from an ordinary day. And you'll actually see, even from the standing orders, they define days differently as in the context of a parliament. So, my lord, that means...
I'm familiar with that parliamentary business day, even in Westminster, especially in Westminster, a parliamentary business day can even be a week. That I get. But why then for external communication to the rest of us who know a day ends at midnight, begins at midnight? Why then tell us a decision was made on the 20th? We don't care. As a Mwananchi, we don't care about arcane Westminster principles. We just wanted to know the date when a decision was made.
Thank you, my lord. You have to look at the context. To whom is the Speaker Senate making that communication to? He's making that communication to the County Assembly of Men, which is another
the clerk.
Yes,
Maybe
the clerk.
I can give you that. I can give you the clerk was speaking to another
clerk
who may also know the...
For the clerk.
But what about the Gazette notice for the rest of us?
For purposes of the Gazette notice, I let actually my colleague highlight further on that. But my lord, perhaps let me give it to my co-counsel and he can shed more light on it.
Okay, but your time has been off, so you've not suffered any prejudice. Yes.
I think
Just a moment, counsel. You'll come in after.
My name is Mwangaza.
Yes.
My lord, the way I understand it is that a parliamentary day is not an actual calendar date. I think we all agree on that.
Yes. A parliamentary business day is not the same as a calendar date. Yes.
And the way I also understand is that the resolution, which is the resolution of parliament, is dated on the parliamentary day on which that resolution was made. Such that the communication to the external world, of course, council has qualified the one to the assembly, but even the communication, the Gazette notice that was published in the Kenya Gazette, that is a communication as well. And I think there would be a discrepancy if the communication to the clerk was to bear the parliamentary business day on which that resolution was made, but the Gazette notice that is published for consumption by the public bears the calendar date. So for all intents and purposes, my lord, the way I understand it is that a resolution, whether it is being communicated to Parliament, to another legislative body, or even for the consumption of the public, is dated on the parliamentary day on which that resolution was made.
I'm looking for that Gazette notice. I've gotten a little bit turned around. Councillor Ngoya, which volume is it in?
the rest of us are trying to get it.
So, respondents replying affidavit. It's an extra. So towards the end. Sorry, what page number?
In our volumes,
Yes.
of course I don't have my computer.
I was check page 2,207. 2,207.
Page 2025.
Let's get to this place. I'm just trying to have my notes.
Which volume number of the respondents is that?
I don't have all the volumes to do last year.
Because the last volume I have is a volume number 4 for the respondent.
Page 2045, they were sequential.
Yes, mine ends at 1736. I suspect there's a volume number 5, which I don't have in hard copy. Perhaps. No, theirs would have a. These are only for the petitions. Does anyone have a copy of that gazette?
I have a copy.
Yes, that's all I need to see.
I'd like to make a comment on what my colleagues have been saying all along.
No, this is not the gazette I'm looking for. I'm looking for the one dated 20th of August. Don't worry, I did look at your notes, so I don't have advance notice of what you're going to submit. The gazette notice dated 20th August. Yes, I'll accept a laptop. First line, because this was my recollection. First line. That's why I separated the clerk speaking to the county assembly and this other one. It is notified for the information of the general public. Then that and gross misconduct, gross violation of the Constitution, gross misconduct, abuse of office, dated the 20th of August 2024. Thank you, Council.
I just have one comment, by the way.
Yes.
Your question to Mr. Mwangaza was simple. My other colleague who expanded the scope of that question. The question to me was whether, as I had it, whether the clerk at any place in his supplying affidavits explains why he dated it 20.
Yes.
And the answer, as I got it from Mr. Mwangaza, is that there is no explanation of the clerk. So that, I think the answer is there. The only challenge is when my colleagues now begin explaining from the back about parliamentary tradition, first without asserting the source of that expertise.
They said AXA in...
But if we have to take them for their word,
yes.
then one will have to look at the petitioner's volume number 1A,
yes.
8367, which is Parliament's own Hansard.
No, that is not in doubt,
Yes.
Council.
So that Parliament's own Hansard shows that Parliament acknowledges actual times and actual dates. So this is a parliamentary own document. If my colleagues want to tell me that the clerk of the Senate communicating with the clerk of the county assembly will have some understanding of parliamentary time, there will be no clearer understanding of parliamentary time than the Senate capturing its own records in its own answer. And they tell us 21st August 2024. That's the understanding of their time. And more importantly for me, there's then the parliamentary business, that's the debate and resolutions. Yes. Then there are the administrative communications of those decisions. Those are two different things. In this court, for example, my lord, you will make an order on a particular day. That order will permanently remain made on a particular day. But the moment the registrar is extracting that order, he will communicate the date when that order is issued, as and when we get along. So that becomes critical for communication to the public.
So I'm not recorded any of that. My question, Councilor Mwangaza, is the gazette notice begins, it is notified for the information of the general public, and then it's dated 20th. The purpose of the date, to my understanding of a gazette notice, is to say the date it was issued as such, and it is for the general public. Can the general public then be expected to know these arcane Westminster traditions? Or can we then say that that decision was made on the 20th, calendar date 20th?
Your Lordship, I still maintain the decision was made on the 20th. In fact, Your Lordship, if you looked at the specific allegation, was that the debate took place on a date not gazetted.
Okay. All right. So let's leave that. Let's leave that there. The only thing I've recorded for all that, it's just so that I'm settled in my mind. A division is only called when it is a matter that affects the county, so that we go into delegations. That was the last thing that I recorded.
Yes. Your Lordship, just to pick up from where I left,
Yes.
that the delegation means that every senator in charge of a county delegation has to vote, Your Lordship.
Yes.
And remember, Your Lordship, that happened for the second division exercise, the one for voting on the impeachment, as well as voting on the debate for limitation of time, Your Lordship. Your Lordship, inevitably that means a lot of time is spent on that exercise, Your Lordship. And in
Yes.
that understanding, Your Lordship, and on the basis of the rules that I mentioned, Your Lordship, then interruption can only occur after the business of the day is complete, Your Lordship. Your Lordship,
You have about 20 minutes. If this is not a very controversial issue, that they will spill over
Yes.
into the next day, perhaps you can use your 20 minutes or so on something that is in contest.
Your Lordship, just to summarize that point,
Yes.
if I annexed the Gazette notice, that is 16th of August,
Yes.
and it specifically says that the sittings shall be held on Tuesday, 20th August 2024, commencing 9 a.m. until the conclusion of the business of the day. That is in
Yeah,
the
that is not in context. In
So,
context.
Your Lordship, let me quickly move to the next point that had an issue, Your Lordship. I'll go to the question of sub judice, Your Lordship.
Yes.
Your Lordship, the simple submission under sub judice or any matter for that fact that calls the attention of the Senate is that it must be raised as a preliminary issue before the Senate, Your Lordship. This is under Rule 14 of the impeachment rules, Your Lordship.
Yes.
Your Lordship, just by way of example, Your Lordship, the County Assembly raised preliminary issue, Your Lordship.
Yes.
Your Lordship, if you look at the Hansard of August 19th, 2024,
Yes.
at page 13, Your Lordship, of the I'm just trying to confirm whether it was the morning session. Of the morning session, Your Lordship.
Yes.
There is a part where Mr. Ndego Njiru, counsel for the County Assembly, makes the following remarks, Your Lordship.
Yes.
Mr. Speaker, sir, I seek your guidance and leave before we make our address on Rule 10 of the Standing Orders and Article 50 of the Constitution in respect to a preliminary issue that has arisen, and Rule 14 as well, which states that any preliminary question or issue raised by the County Assembly or the Governor shall be argued for not more than 30 minutes unless the Speaker otherwise directs the Lordship.
Yes.
Your Lordship, you've been told that attention was drawn. In fact, let me use Councilor Ngoya's words. I hope I quote them right. That was drawing attention by way of a letter, Your Lordship.
Yes.
Your Lordship, these rules were served on all parties, both the County Assembly and the Governor's side, Your Lordship. On 14th of August, Your Lordship, I've done it in my narration of the facts.
Yes.
Your Lordship, those rules are the rules that govern this impeachment, Your Lordship.
Yes.
And in any case, Your Lordship, this is not the first time that the Governor is coming for the impeachment. we understand these procedures, Your Lordship, that a preliminary issue will be raised, Your Lordship. So when that preliminary issue was raised, I'll just quickly go to the next page, which is page 14, after the page 13 I had made reference to. That is when counsel for the governor, my senior Mr. Elisha Ngoya. Now, this is, I'm looking at the Senate Hansard of August 19th of 2024. Now I'm going to page 14, the morning session. Your Lordship, when counsel was given the chance, he actually just responded to the issues raised by the county assembly, Your Lordship. He never made any mention about the subjudice and all of those things, Your Lordship, for purposes of the speaker making a determination as a preliminary issue, Your Lordship.
We seem to be having different references, which is the challenge I'm having, because page 14 that I have would have a different story. We have a certified copy of the answer here, the page 14. My apologies for that, I don't understand. Because if you look at volume 1A, which is a certified copy of the answer, so let's check. Yeah, I'm there. That's page 14 now of the bundle. My apologies for that. I'll bring an affirmation of it.
Your Lordship, as I was continuing, counsel does not raise any issue for purposes of it being considered by the Senate, Your Lordship. And Your Lordship will bear in mind that the question of subjudice is not a question for the respondent to determine on his own, Your Lordship. It is a question to be put before the House as a preliminary issue, Your Lordship. Now, Your Lordship, that having not been mentioned, towards the tail end of the proceedings, and particularly on the governor's closing submissions, is when counsel raises the issue of subjudice at the tail end of the proceedings, Your Lordship. At length, on Friday, counsel brought to your attention the exact words he used, Your Lordship. But what you are not told is that happened at the tail end of the proceedings, Your Lordship, at the closing submissions of the governor, Your Lordship. Equally, Your Lordship, you've been told that Senator Halwale raised a point of order about the issue, Your Lordship. But Your Lordship, that issue is being raised at the time when the Speaker has put the question, Your Lordship. And Your Lordship, the rules of the Senate particularly Standing Order 96 of the Senate Standing Orders provides that no senator shall speak to any question after the question has been put by the Speaker, Your Lordship. And in the same regard, Your Lordship, you will have time to look at the answer for that particular moment. What happened is that the Speaker actually ruled the said senator to be totally out of order, Your Lordship. The rules do not allow that, Your Lordship. So then what does that mean, Your Lordship? If you raise the issue of subjudice at the tail end in your closing submissions, Your Lordship, because having not raised it at a preliminary stage, Your Lordship, so that the Speaker rules on it simply means that as part of your closing arguments, you raise that issue, Your Lordship. So that means when senators are voting, then they consider it as part of your general submissions, Your Lordship. So if they find to the contrary, or if they vote otherwise, Your Lordship, then how do you come and say that this issue was raised and was not considered, Your Lordship? Is it an appeal? What exactly is it, Your Lordship?
You have 10 minutes.
Yes, Your Lordship. I will not speak much to that issue. I will quickly move to the substantiation of particulars, Your Lordship, whether the threshold is met. Your Lordship, from the face of it, I was surprised when my senior on Friday asked you to conduct both a procedural and a merit review of that decision in the Senate, Your Lordship.
Yes.
Your Lordship, a merit review of that decision means that this court is going to sit as the Senate. That this court may substitute its own decision with the decision of the Senate, Your Lordship. I submit that that is not what the law provides.
Yes.
Your Lordship, by way of example, the law only requires, and I'll just avoid quoting the laws, that the allegations are substantiated. That's section 33 of the County Government Act. The word is substantiated. And in any case, Your Lordship, even one ground, the substantiation of one ground is enough to impeach the governor, Your Lordship. Your Lordship,
Yes.
there is no evidence of bad faith or ill intention on the part of the Senate. And in this regard, I make reference to the Supreme Court case in the Mike Sonko decision, where the court actually found that there was no evidence of a predetermined outcome, Your Lordship.
Yes.
And Your Lordship, just to put it into perspective, I am wondering what will happen one day if now the Senate acquits, and maybe at that time the Assembly comes to you and tells you the Senate follows the Senate decision to acquit and say that the governor should have been impeached, Your Lordship. And then ultimately maybe this court is going to make a finding that yes, the governor now is impeached at that point. It would be absurd, Your Lordship. And that is why a merit review of the decision is not open to this court.
Yes.
Just briefly on, I think I had said last, but let me just do one last issue, with your permission, Your Lordship, that whether there was a valid court order, I won't go into depth about that, but my submission is that at the point the Senate was considering this impeachment, there was no valid court order, but I will let the interested parties speak more about that. And Your Lordship, barring any clarification,
Yes.
or questions that you wish to put to me,
Yes.
I would like to conclude my highlighting at that point.
Thank you. I do have 3 questions for you. You finished with 7 minutes to spare, which I will highly encourage. Do you have a copy of the Senate standing orders?
Yes, sir.
Standing order 103?
Yes, I have it, Your Lordship.
So what is standing order 103 about?
Your Lordship, standing order 103, in essence, is,
Marginal note?
yes, matters sub judice or secret, Your Lordship.
So Standing Order 103 begins by saying, subject to paragraph 5, no senator shall refer to any particular matter which is sub judice or which by the operation of any written law is secret. A matter shall be considered to be sub judice when it refers to active criminal or civil proceedings and the discussions of such matter is likely to prejudice its fair determination. And then it proceeds onwards. What should I make of Standing Order 103 vis-a-vis, because you had not mentioned Standing Order 103, that's why I raise it, vis-a-vis the others that you mentioned, including the impeachment rules?
Your Lordship, I mentioned it in my submissions, I just didn't highlight on them.
Yes.
But I will perhaps send the court directly to Standing Order 103.5, which is in my submissions. I thought.
Yes.
Yes. Your Lordship, it provides that notwithstanding that standing order, the Speaker may allow reference to any matter before the Senate or committee, Your Lordship.
Okay, so that was my second question. You said that preliminary issues, let me read what I recorded. Preliminary issues are not determined by the Speaker, but rather the House. But then Standing Order number 103.5 seems to say something different. The Speaker may allow reference to any matter before the Senate or a committee. So an exception to sub judice. So it appears that it was the respondent's role to determine whether to allow the objection.
Yes, Your Lordship, the question here is, I think the time, because the time when this issue is raised. Remember, Your Lordship, when in the application of Standing Order 103.5, this is after the matter is before the Senate, Your Lordship. When the matter is at the floor, where the Speaker has to make a ruling, Your Lordship, it has to be raised, not in his private quarters or capacity,
Yes.
receiving a letter and then proceeding to decide that yes, this issue. These are questions for the Senate, Your Lordship. And the Speaker is empowered in that sitting, Your Lordship, not in his office or somewhere else, to make that ruling when the issue is raised before the Senate, Your Lordship. That is our submission.
So the last is where the court situates the impeachment rules. Are they part of the standing orders, subordinate to the standing orders, parallel to the standing orders?
In fact, if you look at the rules,
Yes.
the schedule, for instance, I refer to second schedule, which provides for the rules for the standing orders, which provides for the rules of procedure for removal of
President.
by impeachment.
Yes.
It actually quotes standing orders 17.
It's a wider question. What happens generally? So let's just look at an act of parliament. What happens if the schedule and the substantive section of the law which derives its power from its authority prosper? So can the schedule derogate from 103?
I do not think so. It should, in fact, in my view, the same way we interpret the Constitution,
Yes.
the document should be read as a whole, with no single provision trying to host the other or circumvent the other. Your Lordship. Our position is that these rules must be read as a whole, Your Lordship. Not in isolation.
Thank you.
My Lord, perhaps I can add some context.
Yes.
My Lord, I don't know the exact provision of the Senate's standing orders, but given a chance, I can refer the Honorable Court to it. The rules generally become that any rules made, the appointees in either the County Assembly or the Senate that deal with rules, any rules made must be appended to the standing orders. So the rules themselves, they are an intrinsic part of the standing orders. They are never read in isolation of the standing orders.
So the county assembly was to have 1 hour as well. Just a moment, let me reset the time. Yes.
Yes, my name is Mwangaza. I will begin from the first issue that just to buttress what Mr. Mwangaza submitted on. The issue of the orders that are sought in this petition, my lord.
Yes.
You will note that the orders that are sought seeking to quash the decision of the Senate. I think that is order number H, prayer number H, a declaration that the Senate, the Senate is not apporting these proceedings, my lord. And I think Council referred you to the other prayers where declarations are equally sought against the Senate and some even referring to the Assembly. But the point I want to make is that contrary to what I think the petitioner is an authority they referred to previously,
Yes.
that is Speaker of the National Assembly versus Center for Rights, Education and Awareness, which is a court of appeal decision.
Speaker of the National Assembly versus
Center for Rights, Education and Awareness. It's a 2019 decision, my lord. In that decision, my lord,
yes.
the speakers of both houses, that is the National Assembly and the Senate, have been sued. And I remember my learned senior Elisha was submitting on this issue
Yes.
extensively, and his position was that when the Speaker of the Senate is sued, it ought to be taken that equally the Senate is sued. That authority, my lord, is distinguishable from the matter at hand. Because if you look at paragraph 17, I believe paragraph 17 of that decision, my lord,
Yes.
all the orders that were granted by the High Court, that is Justice Mwangaza, were orders directed to the Speaker of the Senate and the Speaker of the National Assembly. There were no orders issued against the Senate because the Senate was not a party on that matter, my lord. Moving on, my lord, I think it is important that I point out the documents that the Assembly will be relying on.
Yes.
My lord, we filed a replying affidavit, the field interested parties replying affidavit sworn on 16th of January of 2025, together with the index of annexures, that affidavit.
Yes.
The submissions dated 11th of February of 2025, together with the list and band of authorities that are filed alongside the submissions, my lord. And at this moment, my lord, I seek the assistance of your court assistant. That is the entire bundle of documents that the Assembly will be relying on. Perhaps they can be prosecuted to the desk for ease of reference.
Yes. So that when you go back to your respective clients, in case they ask you why Mwamuye J is taking 21 days to write a judgment, perhaps you can mention Mwamuye J will go past through more than 10,000 pages. It is more than 10,000 pages.
We'll see whether you give, my lord.
Yes.
My lord, I will foremost begin by explaining the impeachment process. My lord, the impeachment process begins with collection of signatures at the Assembly.
Yes.
Standing order number 65 of the County Assembly standing orders. And this, my lord, is
Standing order number?
65, specifically 6501 of the County Assembly standing orders.
Yes.
which are to be found on pages, a specific page is 1678, page 1678, in
Yes.
their next term as JK41D.
Yes.
My lord, once the intended mover meets the threshold, that is the other of the members of the assembly, and the speaker approves that motion, it is then tabled on the floor of the house.
Yes.
And pursuant to Standing Order 65(2), the mover gives 7 days notice calling for the impeachment of the governor. Pursuant to Standing Order 65(3), my lord, upon the expiry of the 7 days,
Yes.
the motion is placed on the order paper and disposed of within 3 days. So, my lord, the entire time that the county assembly has, right from filing that motion with the office of the clerk, to giving notice, to consideration and passing a resolution,
Yes.
either in support of or to defeat the motion, is 10 days. 10 days is the maximum amount of time that the county assembly has. That upon approval, if that motion succeeds at the assembly with the 2/3 threshold,
Yes.
that resolution is communicated to the Speaker of the Senate within 2 days, pursuant to Section 93 of the County Governments Act, my lord.
Yes.
And the Senate convenes, the Speaker of the Senate convenes the Senate to consider that motion.
Yes.
So, my lord, the role of the assembly is to initiate the impeachment process.
Yes.
My lord, the decision in Martin Nyaga Wambora, that is Civil Appeal number 21, it is in our list and bundle of authorities at page 111, spilling over to 112.
Yes.
This decision, my lord, by the Court of Appeal, holds that the role of the assembly is to initiate the impeachment process.
Yes.
And, my lord, if I can read verbatim, there are 3 sequential steps to be followed. First is initiation of a motion to remove the governor by a member of the county assembly. Second is consideration of the motion and a resolution by 2/3 of all the members of the assembly.
Yes.
And that the Speaker of the assembly is to forward the county assembly's resolution to the Senate for hearing of the charges against the governor. So, my lord, what is the role of the Senate? We submit that the role of the Senate, my lord, pursuant to this decision, is to hear the charges against the governor. Section 33 of the County Governments Act, my lord, and Rule 2. Rule 2 of the Senate Rules of Procedure
Yes.
equally provides that the role of the Senate, my lord, is to investigate the charges and to determine whether the particulars have been substantiated. Once Senate considers the impeachment charges, my lord, and makes a resolution,
Yes.
the dispute might find itself to court, as we have found ourselves, my lord, before you. The question that then arises is, what is the role of the court?
Yes.
My Lord, we submit that the role of the court is to review the processes at the Assembly and the Senate to establish whether individual rights of the petitioner have been violated. Ordinarily, my Lord, that would be the role of this court. But my Lord, this is no ordinary petition.
Yes.
Because the petitioner, my Lord, does not complain about the processes at the Assembly. My Lord, I'll refer you to the further affidavit.
Just a moment.
Can I proceed, my Lord?
No, just a moment. Yes, proceed.
My Lord, I refer you to paragraphs 91 and 92 of the petitioner's further affidavit.
Yes.
My Lord, I'll read verbatim what the petitioner says. Imperative to note is the fact that the amended petition does not at any point make any allegations against the County Assembly of Meru, and neither are there any relief sought against the fifth interested party, which is the County Assembly of Meru, as per its assertions and the paragraph of its affidavit. That paragraph is omitted. A paragraph 92, my Lord, the petitioner goes on to say as follows: I could not help to note that the 4th, 5th and 6th interested parties, through their responses, have framed a new cause of action against them and sought to respond on the very extraneous issues unrelated to the issues raised in the amended petition. If you turn to the next page, my Lord, a paragraph 29, the petitioner deposed as follows: there are notable fact and distinction is that the cause of action in the instant petition arose at the Senate and not at the County Assembly. My Lord, what is this court supposed to make of those words? Those depositions by the petitioner under oath?
Yes.
My Lord, the petitioner has made no allegations against the Assembly. The petitioner seeks no reliefs against the Assembly. The petitioner does not complain about the processes of the Assembly.
Yes.
And even faults the Assembly for responding on what she calls extraneous issues that are unrelated to this petition. So, my Lord, as you exercise your role, as you sit as an arbiter over this matter,
Yes.
we submit, my Lord, that your role is only limited to reviewing the processes at the Senate and not at the Assembly.
Yes.
My Lord, the province of this court, as we are told, is Mwangaza Wambora. I'll take you back to that authority, my Lord.
Yes.
Mwangaza Wambora, page 112, paragraph 32, tells us that the province of the court is solely to decide on the rights of individuals and not to inquire how the County Assembly and Senate perform duties in which they have discretion. Well, Lord, in our case, it is only the Senate, not the County Assembly, because there are no allegations. The petitioner complains not against the County Assembly, and therefore your role is only limited to the procedure at the Senate. My Lord, if you look at the amended petition, who are the parties, my Lord? It is Honorable Mwangaza's petitioner, was the Speaker of the Senate. The County Assembly is a party, my Lord. I believe this is uncontested. We became a party on account of the oral application for Zoila reviewed on the 18th of September, on the 18th of December, my Lord. Sorry. My Lord, if you look at the authority, at the decision in Martin Nyaga Wambora, Civil Appeal number 21, is appearing on page 104 of the Assembly's list and band of authorities. The County Assembly was the 6th respondent.
Yes.
If you go to Sonko, my Lord.
Yes.
Just a moment, my Lord. The decision in Sonko, my Lord. The County Assembly was the third, the Nairobi City County Assembly was the third respondent.
Yes.
The Speaker of the Nairobi County Assembly was even sued as the second respondent. Unlike in these two cases, my Lord, the petitioner has no cause of action against the Assembly, and therefore, my Lord, it must be that in exercising the jurisdiction,
Yes.
the petitioner has confined you to the processes at the Senate.
Yes.
My Lord, what is the review jurisdiction of this court? What is the remedy or the extent of the review jurisdiction by this court? Our position, my Lord, is that the jurisdiction of this court does not extend to a merit review of the decision or the resolution by the Senate. For now, we are not bothered with the Assembly, just with the Senate. Because, my Lord, if this court, my Lord, was to conduct a merit review
Yes.
of the decision of the Senate, this court would be supplanting its own decision, substituting the decision of the Senate for its own.
Just a moment. Let me take your time off. Let's go to the amended. Let's go into the amended petition, and we can look at the prayer. I'm interested in prayer number I.
Prayer number I, I'm there, my Lord.
Yes, please.
Yes.
An order of Sachi Orarai it's been spelled the way we should pronounce it, to remove this honorable court and quash the decision and or resolution of the Senate made on 21st August 2024 resolving to remove the petitioner from office by way of impeachment. That was initially a judicial review prayer, remedy, relief. Then it was constitutionalized. Can that be issued in a procedural case?
Indeed, my Lord.
So,
if I can explain, my Lord.
yes.
This court, in reviewing the procedure at the Senate, if this court was to find, my Lord,
Yes.
that the rights of the petitioner were violated.
Yes.
By way of example, if this court was to find that the petitioner was not afforded an ample opportunity to present a defense, that's a violation of a right to fair hearing.
Yes.
This court can quash that resolution.
So let's look at the previous prayer, which is prayer H. It is declaratory in nature, though.
A declaratory, that is prayer number H?
Yes, H.
Yes.
Please read it.
A declaration that the Senate, in its evaluation of the impeachment proceedings before it, failed to properly assess each of the specified grounds and determine if they collectively or individually constituted gross violation of the Constitution, warranting the removal from office by impeachment of the governor. Hence, the resolution of 21st August 2024 does not meet the threshold for impeachment set out under Article 181 of the Constitution, hence the same be and is hereby certified.
To the fifth IP's mind, is that merit or is that procedural?
That is merit, my lord, and that is why we invite you.
Okay, so your time is back on.
Yes, my lord. My lord, those two prayers, foremost, are sought against the Senate, which is not a party. I think it is important that we clarify that. Two, this is an invitation, my lord, for you to look into the merits of the decision by the Senate. An invitation we humbly urge you to decline. My lord, we find strength in that submission, my lord, in Martin Jaga Wambora, page 112 of our submissions, my lord, our list and banner of authorities. The province of the court is solely to decide on the rights of individuals and not to inquire how the county assembly and senate perform duties in which they have discretion. We find further strength, my lord, in the Sonko decision, paragraph 112, where the Supreme Court stated as follows, and I quote, likewise, in Justice Kariuki Mate and another versus Martin Nyega Wambora and another Supreme Court petition number 32 of 2014, this court signaled that it would be reluctant to question parliamentary procedures as long as it did not breach the Constitution, and that the mandate of the courts is restricted by the doctrine of separation of powers to deciding on matters of individual rights and fundamental freedoms, and not to inquire into how the county assembly and senate perform duties in which they alone have discretion, or to review the merit of the decision by the county assembly and senate to impeach government. We submit, my lord, that you are guided by those two authorities.
Yes.
My lord.
I will record you are bound.
Indeed, my lord.
Yeah.
Bound. Bound is the word.
Yes, proceed.
My lord, in exercising that review jurisdiction,
yes,
to relook or to review the processes at the Senate, we submit that, my lord, in that very limited review that the petitioner has confined you to, in which, for the record, we have no problem with, this court, my lord, should also be aware
yes,
that the role of the Senate is not to reassess the procedures at the Assembly.
yes,
Such that, my lord, all the instances where the petitioner faults the Speaker of the Senate or even the Senate for not correcting what in the petitioner's views were errors at the Assembly, my lord, we submit that that is not the authority of the Senate. The Senate has no authority to review the procedures at the Assembly. Perhaps that is why, my lord, in that sequential or hierarchical separation of the distinct jurisdictions of all the three bodies, this court ultimately has the power to look at the procedures at the Assembly. The Senate does not have that power.
So let's assume that the county assembly, let's give a situation that would never occur.
Is my time closed, my lord? Can I have
Yes, yes, it is. So the county assembly does not, there is no mover. They just go straight to the end. There was no vote, no nothing. Just the Speaker of the County Assembly forwards the decision to the Speaker of the August House. He's saying that, and then it is raised as a preliminary issue. Are you saying that in that instance, the Senate would not be able to say there was such and such procedure established by the law and by the County Assembly's own standing orders, it was not followed, breach of procedure, we are not hearing this, we reject it?
My lord, my understanding is one,
Yes.
that any grievances that ought to be raised to the assembly cannot be taken on appeal. Such that, my lord,
Yes.
Senate does not sit on appeal of the decision by the county assembly. The role of the Senate under section 33, and also I believe rule 2 of the Senate rules of procedure, is to investigate the charges and to determine whether the same have been substantiated. If
Ni Baite TV, Baite FM, 90.1, Kodongi Pweto. Ni Baite TV, Baite FM, 90.1, Kodongi Pweto.
entire bundle, there's 40 extras. The bigger bundle, my lord. Okay. 21 to 40. On page 48 to 66, specifically on page 65.
We have seen in the further affidavit, my lord, paragraph 99.
Sorry, which volume is this?
It's
Is it the one that starts page 1 of 421? What is the page numbers at the bottom? That's the easiest way for me to
It's
read.
65 of 3559.
3559.
Yes, yes.
So
Page
you
65.
want me to go to page
65, my lord.
we still have
It's marked JK1, my lord, to JK40 in the top right corner.
JK1.
Yes, to JK40. There's 40
Yeah,
answers.
I found it. Page 40.
Page 65, my lord.
Sorry, page 65. Yes, and your time is off.
Yes, my lord.
Yes.
My lord, the reason why the petitioner, and we do not complain that we have not been included, my lord. Well, we complain in terms of Muruatetu, that we are denied an adequate opportunity to respond, given that we are not a primary or principal party. But part of the reason why we were not included, my lord, is so that we don't bring these facts to your attention.
Yes.
That the petitioner has packed another petition in here, seeking the same order that is sought before you, my lord. That is a declaration that section 93 is unconstitutional. That is paragraph prayer number D, my lord, in that petition, petition number 13 of 2024, which is a prayer in rem.
Yes.
My lord, to the extent that that prayer is sought in that petition,
Just a moment. So your time is back on.
our submission, my lord, is that this is the mischief behind the decision not to include the assembly as a party.
Is this matter active?
It is active, my lord. It is the matter where that ruling was given. That's
Sorry, is the petition active?
directions are yet to be given on the hearing of the petition. That ruling was read last week, and the party should now proceed to the hearing of the petition, my lord. It's petition number 13, E013 of 2024.
So the overlap between the two is only in terms of, if there's an overlap, is only in terms of prayers, prayer D.
There is prayer D, my lord, and also the issue of the conservatory order. Because in this petition, my lord,
Yes.
the ruling will address you on the issue of the conservatory order, whether there was a conservatory order in the first place. That ruling has never been given in this matter.
Hold on. When you say, let me just switch off your time. When you say conservatory order, what do you mean?
It is a ruling, it is the application, you know, my lord, there are two applications in this petition. The first application, and I will lead you to the evidence, my lord, when I get there, but because you've asked me, I should clarify.
Yes.
It is, there was an initial application dated 18th of July 2024 with regards to the first impeachment motion that was dated on 15th of July 2024. Then there was a subsequent application now specific to the impeachment motion dated 31st of July of 2024.
My understanding of the application before me was it was with respect to the Senate, stopping the Senate resolution from coming into force. Is that correct?
The petition that is before your lordship.
Yes, this one that we're doing now.
Yes,
That is the interlocutory order.
Seeks, of course, to quash the resolution in the Senate. Yes.
This one cannot make the reference to that. It was dated before the matter had even gone to the Senate.
Indeed, my lord, it
it was dated before the matter went to the Senate.
Yes.
But prior D that he sought, that declaration of unconstitutionality of section 33
Yes.
is a prayer in rem, that is the first thing.
Yes.
2, it is sought by the same petitioner. And I think paragraph 99 of our father affidavit, my lord, lends credence to this argument that she has split the cause of action. There is one in Meru against the county assembly, and now another one in Nairobi against the Senate, against the Speaker of the Senate.
Okay, I've not understood your. I've not understood your point on interlocutory relief. Any possible overlap between the two cases?
My lord, the point is,
Yes.
the question whether there was a conservatory order stopping the impeachment motion dated the 1st of July 2024 that was approved by the Senate. That
Yes.
question is before you for determination.
We canvassed this on Friday at quite some length.
Indeed, my lord.
Yes, I've switched off your time so that we can pick it up, but this time we'll not go to the petitioners.
Yes.
I'll just deal with the persons who have opposed.
Yes.
So there's a ruling of the High Court sitting at Meru dated 13th February 2025, which has found that there was an order capable of a contemptuous acts being committed.
Yes, my lord.
Isn't that the end of that? I cannot sit in review of my brother.
It is not the end of it, my lord.
Yes.
And we will seek to persuade you, my lord, that one, we are not inviting you to review or to sit on appeal
Yes.
of that ruling by your brother Justice Edward Murray.
Yes.
Secondly, my lord, that ruling, the gravamen or the gist of that ruling was on the question of content.
Yes.
That ruling does not determine the question whether there was a conservatory order. That is an issue that question was brought before you for determination by the petitioner. So the question whether there was a conservatory order has not been decided. What the court in Meru decided on are matters of content.
I've had the benefit of reading that decision, and you also have as well. Your time is off. So my brother sitting in Meru found that the act of withdrawing the motion and then refiling another motion, the motion that led us to today, was an act of contempt. Is that found within that ruling?
Yes, my lord.
So when you submit to me about that, aren't you asking this court to re-examine a factual finding that was made by Meru?
My lord, the finding, and perhaps that is where you don't seem to agree, is the finding is on the issue of...
No, I've not yet made up my mind. That's why your time is off. I want, because it's a very, very grave thing for myself to purport to re-examine something that my brother or my sister has already determined. So I want to be very, very careful. I want to know that I can confidently do it. So just explain the distinction between what happened in Meru and was determined in Meru and what is before me.
My lord, the ruling in Meru
addresses
the issue of content. And the issue that was before court, the application that was filed by the petitioner, was the application dated 1st of August. It's somewhere in our bundle of documents.
Yes.
An application seeking, one, to cite the...
Let's go to that application.
Yes,
I can see yours has nice tags. If you ever have another impeachment or any other matter before me, I also like tags in my documents.
I will appear before you. I will never do that. There is an application dated
the application begins on page
56.
52.
256 is where the motion begins.
Yes, 256, my lord. Yes. This is the first application, my lord,
Yes.
seeking a conservatory order against the respondent, which is the County Assembly of Meru, suspending the debating, considering, and or acting upon the motion. The wording, my lord, is upon the motion.
Yes.
For removal of the applicant from office to impeachment. This prayer, my lord, was sought ex parte. It was never granted.
Yes.
The order, my lord, that is subject to that ruling, the ruling of the 13th of February, is the ruling where, and I think Messiah Ngwaya was referring to that. He was reading verbatim where your brother Justice Kassan held that the upshot of this ruling, that was the ruling that was subject to the application for contempt.
Yes.
Yes. This application, my lord, the application on page 256, the motion on 257, my lord, the prayers, is on the motion dated 15th of July.
Okay, so go to 415 of the same bundle.
415, my lord.
Yes.
And then, my lord, this is the subsequent application
Yes.
on the motion specific to the motion dated 31st of July of 2024.
Yes. So there was a prayer number 5 to that.
Yes.
That pending the hearing and determination of this application inter partes, this honorable court be pleased to issue further conservatory orders against the respondents, prohibiting them from debating, considering, deliberating on the notice of impeachment dated 31st July 2024, or in any other manner in whatsoever nature reintroducing any impeachment notice against the petitioner applicant.
Yes, my lord.
Yes.
My lord, those two prayers, I should call them maybe sets of conservatory orders,
Yes.
on 256, 257, and 416, specifically prayer number 5, those conservatory orders were never granted. To this day, my lord, those prayers have never been granted. They were sought ex parte, orders were never granted ex parte. The petitioner has not furnished you with any order, conservatory order, that was granted ex parte, or even upon inter partes hearing. No such orders were granted.
Okay. Let me understand why you're dwelling so much on the ex parte aspect of it.
My lord, I'm not just dwelling on the ex parte
Yes.
aspect of it. What I am saying, my lord, is the orders, whether ex parte or inter partes, the conservatory orders, whether sought or prayed for ex parte
Yes.
or inter partes, were never granted to this day.
So what did my brother Raythi J find was the contemptuous act?
The contemptuous act, my lord, was with respect to the ruling that was given on 24th of July.
Yes.
And that
Which
ruling, my lord,
halted any...
perhaps you can go to that ruling, my lord.
Yes.
It's on page 294, 298.
So I'll read the last two paragraphs of that ruling. This court must also take note that this is the fourth time the petitioner is facing impeachment. The other three attempts failed. It is in the interest of the public that the petition is decided at this stage to pave way for future smooth process, because so far resources and judicial time has been spent. The upshot of the above is that the impeachment process is halted pending my ruling, and since this is a matter of the public interest, the rulings, PO, interested parties and main petition will be delivered on Monday, the 29th day of July 2024 via email to all parties. There was then a subsequent deferral and a fresh fixing. Yes.
My lord, my submission in that regard, my lord, is that that ruling is one specific to the impeachment motion dated 15th of July. It is not, there was no grant of a conservatory order in that ruling.
I have read that ruling. You've read that ruling.
Yes, my lord.
The central part is this: the upshot of the above is that the impeachment process is halted. Not a specific motion, which is why
yes,
then,
yes, my lord.
just a moment, which is why then my brother sitting in Meru then found that the act of reintroducing another motion was itself contemptuous of that aspect of the ruling. Be that as it may,
Yes.
because I am not the Court of Appeal.
Yes.
The reason I've also put your time, I've halted your time, is I want to make clear, unless you can make me see that there is something completely outside of what my brother Kassan J and then subsequently Mureithi J dealt with, I cannot safely record.
My lord, foremost,
Yes.
my submission is as follows, my lord.
Yes.
That his order is, the upshot reads as follows. The upshot of the above is that the impeachment process is halted, pending my ruling, and since this is a matter of public interest, the rulings, that is the preliminary objection, interested party, the main petition will be delivered on Monday 29th. So my lord, this is an order halting the impeachment process. Our submission in that regard, my lord, is that the impeachment process that was live before court on that date is the impeachment process premised on the impeachment motion dated 15th of July of 2024. That order, my lord, was not forward-looking.
Yes.
It was not prospective. And my lord, maybe to give you context,
Yes.
if you look at the ruling that was given subsequently on 29th of July by the brother Justice Kassan,
Yes.
at page 310 of our bundle, at paragraph number 3, are you there, my lord?
Yes, to defer the ruling.
Yes, the decision to defer the ruling in order to pave way for possible alternative justice system. Your brother Justice Kassan asks, who will be prejudiced? The respondent will not be prejudiced because the ongoing impeachment process will stop. The ongoing impeachment process.
Be that as it may, counsel.
Yes.
Be that as it may.
Yes.
Perhaps you're trying to convince the wrong justice.
Yes.
Perhaps this is something you should be saying in a court above mine. Because you're asking me to interpret what two of my brothers meant with their rulings.
Yes.
Now, I could possibly distinguish.
Yes.
Yeah, I could. And I've not determined one way or the other which way I would do.
Yes.
But is it so clear and stark that what they meant was a specific motion, or the fact that there were impeachment processes? Because I started with Kassan J's penultimate paragraph, where he says there have been previous motions.
Yes, my lord.
Have you canvassed this in your submissions?
I have extensively canvassed this, my lord,
Okay.
in our replying affidavit, and it's our issue number 1 in our submissions. Though by that time, my lord, the ruling had not been delivered, so it was not brought to our attention. It's a matter, my lord, that we wish to
That's why
address.
I'm saying you've not canvassed it in your submissions. So now I am constrained. And I
My
did
lord,
mention
we have
it.
addressed the
Just a moment. Just a moment. I mentioned it on Friday. Aside from whether or not I can distinguish, there is then the question of what is highlighted. Are we highlighting written submissions that have been filed, or are we now expanding into new territory? In another matter, the abductions case, when there were developments, I had to push back the ruling date so that they could file submissions to cover the developments. There was another case where there had been some developments. So if I let you submit on this,
Yes, my lord.
it will be akin to you filing supplementary submissions.
Yes. I think, my lord, these new developments, especially the issue of that ruling, was orchestrated by the petitioner. Because it is the petitioner in their supplementary submissions who introduced the issue of this ruling. It was a new development. So we did not have an opportunity to respond to that issue because we had already filed our final submissions. But they introduced a new issue in their supplementary submissions. So of course the prejudice, my lord, is on the part of the assembly and the respondents if we do not respond to that issue. And more specifically, my lord, we do not ask you to review or to even distinguish or try to interpret the orders by your brothers. What we ask of you, my lord, is
Yes.
not to be persuaded by that ruling.
Council Mutuma,
Yes, Your Lordship.
what do we do?
For us, where we stand, the Lordship, this is a very clear issue that you want to
No, not in terms, don't argue it.
Yes.
What do we do? Do you have a suggestion? Because I have something that is percolating in my mind. I'm hoping that you will have something better than what I'm considering doing.
Your Lordship, we brought the attention of the court
Yes.
to a ruling that that ruling is part of the legal authorities that the court is asked to look at and either be persuaded or adopt it as it is.
Just for clarity, even if you had not filed, the High Court is deemed to know what every High Court has said. It's a fiction, but I would be deemed to have known that it has been delivered. So I'd have had to at least comment on it. Would you be open to those opposed filing written submissions?
We have not proposed that at all. They can file written submissions in respect to that one aspect.
That
There is no-
one aspect, only limited to 5 pages. There will be no highlighting of that though, so I'll just have to read it. Because I'm eating into so much of my time I was supposed to have started this on Saturday morning, we're now on Monday. If I give you, please sit. If I give you until, what is practical?
Three days on apartment.
Oh no, absolutely.
It can take 2 days.
Have you seen the volumes you guys have given me? This has a judgment date of 14th. I was very clear. Short of Kenya being invaded, I am not adding a single day to it. This is not the only one. I have the abductions one as well. I have quite a number of judgments. So I can't give you 3. I have to start this possibly tomorrow, latest on Wednesday.
We can file by close of business tomorrow.
Close of business tomorrow.
Yes.
There'll be no rejoinder. It's just they file close of business tomorrow.
We're not intending.
So may I then suggest that any reference to how I should interpret that, we just leave it for the submissions.
My lord, if I can just make one point.
Yes.
And you see, our position, my lord, is not that we ask you to review or to appeal your brother's decision. We understand that these are courts of concurrent jurisdiction.
Yes.
The only way that decision can be overturned is on appeal.
Okay, let me explain where I'm coming from. I was once a member of a tribunal with respect to Justice Marete. And I signed that. It was a unanimous decision. I signed that decision where we disagreed that there was res judicata. The central complaint that JSC found had been substantiated to the level required to recommend to the president was that sitting in one court, he determined something interlocutory that was pending before his sister at MILIMANI. And they found it so grave as to recommend for the formation of a tribunal. So res judicata, this idea that two courts can determine the same issue, can be very grave, not just for striking out of pleadings. That's one thing that you can do, or you say this particular part I will skip, it's somewhere else, but it can also create a peril on the individual judge. So if for no other reason than because I don't want to sit in a place at KICC having to explain my understanding of res judicata, can we agree that you file very, very good written submission so that if I'm ever called on, I go and say Mukele filed this, Mawira filed this, and they convinced me. Is that fair enough?
My Lord, I can see my colleagues here.
Yes. Yes, yes, yes.
If I may,
yes.
The petitioner got a chance to sort of highlight at length about that issue.
But you can't highlight something I've not read. See, what I want you to do is also bring those authorities. Because you'll have to say, but that's the challenge, I've not read them. For better or for worse, I've actually read all your submissions, so I know if you want me to then give you a date for highlighting, limited to that, and limited to just yourselves, and maybe limited to 15 minutes, one of you, then we can do it that way.
My Lord, we do not want to stretch this because we want to...
You can do it virtually. You can do it virtually, 15 minutes. But sometimes your submissions are so good that they don't need to be highlighted.
Thank you for that, my Lord.
Yes.
But nonetheless, my Lord, we pray that you are granted the opportunity to highlight, limited to 15 minutes.
Sorry, my Lord.
30 minutes?
My brother's permission. What we got wind of when our colleagues highlighted for 1.5 hours on that issue on Friday is that we felt we also needed to respond, not as per what we put down in writing because we didn't have the chance, but perhaps on points of law and what we feel as lawyers we can be able to tell you as a judge, this is what the law says, but it's upon you to make a decision. To that extent, my Lord, I think you should allow us, even if it's 2 minutes, to just tell you what we feel the law says about this particular situation.
You will want to file authorities, or you want to rely on authorities? Yes.
Unfortunately, yes, my Lord.
So when you want to file authorities or rely on authorities, because this is a long authority, and this is one of the problems that we have with authorities, you can quote a paragraph out of context. So I would still have to go and look for it. And with a time-bound judgment date, it's easier for me to front-load that to yourselves, file the authorities, file written submissions limited to 5 pages, then I can see them.
Thank you, Your Lordship.
Yes.
We have taken note of that, and the authority we intend to ever rely on is a common authority from the Supreme Court of Karaoke Matter, and which our colleagues are well about. The things you also said in the area missions. My Lord, I don't think any harm, even for the court, because as you said, we're taken to know that.
Okay, fine. So what I'm hearing you is you've declined to file written submissions. I can't...
No, you did get me right.
If I can speak for Lord.
Yes.
We are gladly accepting the offer to file written submissions, but also we want to just gloss over those authorities in not more than 10 minutes.
So what then would be the point of filing those submissions?
Oh, my Lord, for the comfort of the court, my Lord, I can speak about just 2 points, my Lord, in not more than 3 minutes. Then we file our written submissions, then we highlight, as you suggested, on a virtual court session. I think we will deal with those issues at length virtually. and it's ready for you to elect.
Nema, please give me my dad. And your time has been off this entire time. There's space on Wednesday. So you can file by close of business tomorrow. You come highlight at 9:30 a.m. on Wednesday, and I will still maintain my judgment date of the 14th.
Virtually on physical court, my lord?
Let's do it virtually,
Thank you.
because I have so many others. Virtually jumping in between courts may not work. Okay, so I'll give you very limited time today, but you do file your written submissions by close of business tomorrow. I will formalize that at the end of today. Yes.
Thank you, my lord.
Your time is back on.
Thank you, my lord. The first point, my lord, that I want to submit on is what you've just raised, the issue of the res judicata. My lord, again, we submit that we are not inviting to review or appeal the decision. That ruling by your brother Justice Maridi. And my lord, it is a petitioner. If at all, my lord, that issue was before the court in May, the issue of the conservatory order. Our position, my lord, is that the only issue that would be res judicata, if you were to consider it, is the issue of contempt. Because that was the issue that was before your brother in May. The issue of contempt, my lord. Such that if you sat and made your own decision on the question of whether there was contempt of court, that would without doubt be res judicata. The question of whether there was a conservatory order, my lord, was not answered by the judge in the affirmative. But even if, let us assume, my lord, that that question was answered by the judge. The question is, my lord, would it be proper for the petitioner to canvass that issue in two courts, in two different stations simultaneously? Would that issue have been canvassed in Meru while being canvassed before you at the same time, my lord? That is the question. And our submission in that regard, my lord, is the petitioner cannot benefit from her own mischief. She brought that question for determination before you. That question was not determined by the judge in Meru in the affirmative. He did not, as a matter of fact, say that there was a conservatory order granted on this date, stopping the impeachment motion dated at the 1st of July 2024.
Yes.
And therefore, my lord, two options are available to you.
Yes.
The first one, my lord, is to appraise yourself of the evidence, the detailed affidavits, and the submissions by the parties, and arrive at your own independent determination of that question.
Yes.
Totally uninfluenced by that ruling. And two, my lord, if you are to find that indeed this matter was being canvassed in two courts at the same time, then the petitioner is guilty of unclean hands, and she cannot benefit from her own mischief.
Yes.
And as we submitted earlier, my lord, this would indeed be the reason why the assembly was not joined as a substantive party in the petition that is before you.
Yes.
In the second instance, my lord, then what you do is to down your tools on that question and failed to determine it altogether.
Yes.
Solely for the reason that the petitioner canvassed this issue in 2 different courts at the same time, my lord.
Do you have a hard copy of that ruling?
I have a hard copy, my lord. Somewhere here.
So I've stopped your time for the upteenth time. Let me read you paragraphs 36 and 37. Clearly, the respondents were in contempt of court to withdraw a notice of impeachment against which orders have been issued by a court. Orders have been issued by a court, and to introduce a fresh impeachment process outside the one subject of a court proceeding in which the court has made injunctive relief so as to defeat the effect of the court order is similar to withdrawing a suit in which an order restraining certain conduct has been made so as to defeat the said order of court. It is a classical textbook case of disobedience of court orders, albeit in crafty manner. It is gaming the system of the rule of law that binds the 3 arms of government in mutual respect. I think there's supposed to be an under separation of powers. The deputy leader of the majority, I believe that is the 6th interested party, withdrew the notice of motion for the removal from the office of governor on 30th July 2024 and issued a fresh notice of motion for removal of governor on 31st July 2024. With respect, the court did not purport or pretend to grant, as submitted by the respondents, immunity. I'll not read the rest. I'll just read the last paragraph, the last sentence, of paragraph 38. When the respondents proceeded with the process of impeachment of the petitioner despite, and indeed in spite of, those orders, the respondents were in clear and mitigated contempt of court. Those words speak for themselves. So I will record what you are saying. I look forward to your written submissions. All that I will caution is, as you're making your submissions, please bear in mind that I have a fairly good idea how one is supposed to distinguish matters. You're going to need a lot more authorities. I can think of a few authorities which may or may not apply to this. Really consider whether this is the best use of our time. I've limited you to 5 pages so that parties don't go too far. But you're going to need quite a lot of authorities, because those paragraphs, those 3 paragraphs, are very clear as to what has been determined. Now, whether or not a motion can exist in 2 high courts, that is something you'll raise in your submissions. Whether then I should disregard and all that I can record safely now because it's an option for me. But how to characterize what was happening in that court, you may need to get some authorities, because even the mere act of recording it is itself potentially res judicata.
I am guided accordingly, my lord.
Yes.
And that is why, my lord, on the part of the assembly,
yes,
and unlike the petitioner,
yes,
we are giving you several options which you can exercise, my lord.
Yes.
We are not telling you that you are bound by that ruling.
Yes.
Especially because it is the petitioner who brought this issue before you for determination. So
yes,
you have several options, my lord. You either determine that issue independently based on the evidence?
Yes.
And if indeed you find that that matter was sustained in 2 courts simultaneously, then the petitioner cannot benefit from that mischief.
Now,
down your tools.
Just a moment, and this time I'll not switch off your time. I can't recall who on Friday stated that there is an appeal that has been lodged in the Court of Appeal, but there are no orders of stay.
That is a correct position, Lord.
What then were to happen if I were to determine one way and the Court of Appeal determined another way on the same?
Indeed, my Lord, and that is why, my Lord, we are urging you. Of course, there are other reasons, such as the painkurium nature of that ruling, and as you well advised, we are going to distinguish it through authorities as we seek to persuade you, my Lord, why you should not be persuaded by that ruling. One, you are not bound by it. Two, we are urging you, my Lord, not to be persuaded by that ruling on account of its inherent errors, the painkurium nature of that ruling.
Yes.
Where the county assembly speaker and the other part, and the mover and the clerk were condemned and hurt. If you check that ruling, my Lord, there were no parties to that case. The court convicted them, my Lord, and proceeded to sentence them without an opportunity at litigation. My Lord, we know that these grounds are going to be made even on appeal as we challenge that decision. But for the moment, we are telling you, my Lord, because of those errors inherent in that ruling, do not be persuaded by that ruling. Even more fundamentally, my Lord, is that this ruling ignores or disregards the binding precedent from the Supreme Court in Justice Kariuki Mate.
Yes.
And I believe also there is another decision, my Lord, we are going to quote them in our submissions, on why in contempt proceedings a party cannot be condemned and hard. This is what the court did. These parties were condemned and hard. And based on that painkurium nature, my Lord, we will be urging you not to be persuaded. But even more fundamentally, my Lord, is a question that, given that this matter was brought before you for determination, can the petitioner honestly tell you that I brought this matter for determination before you, but I have now obtained a favorable ruling from another court where I simultaneously canvass this issue? Your hands are now tied. You are bound by that ruling. You cannot exercise your discretion on that question. Can the petitioner, in all honesty, tell you that, my Lord?
Yes.
Such that whichever way it goes, my Lord, the petitioner cannot be the one to benefit from mischief. And I'm winding up on that issue. Is a question whether...
You have 20 minutes to go.
My Lord, the question whether that ruling that was given in Meru, even assuming, my Lord, and this is purely for argument's sake, even assuming that indeed there was a conservatory order, which you contend there was none, can this court, in exercising its jurisdiction to review the processes at the Senate for violation, to check or to establish where there was violation of individual rights, find and hold that indeed the petitioner's rights were violated? My Lord, the answer to that question is in the Supreme Court decision in Sonko. We are going to highlight it in our submission as well.
Yes.
Sonko, as a matter of fact, had a conservatory order from the Employment and Labor Relations Court.
Yes.
In our case, my Lord, there was no conservatory order. But nonetheless, the Supreme Court held that there was no violation of his rights to a fair hearing. So we will be addressing you on that question as well, my Lord. The question of that is the place of the conservatory order in these proceedings, and whether the absence or presence of it, my Lord, would be said to be violative of the individual rights of the petitioner. My Lord, I will address you on the question of whether the threshold for impeachment was met My Lord, as I earlier submitted, this court is not sitting to conduct a merit review of the decision of the Senate.
Yes.
Kenyans in their own wisdom arrogated that function to the Senate. But purely out of abundance of caution, my Lord,
Yes.
and in order to protect the Assembly's interest in this matter, my Lord, I will address you on that specific question and only limited to the question of, one, what is the legal threshold for impeachment? In fact, that is the only question I'm going to address you on, my Lord.
Yes.
I will answer, my Lord, in response. Is that, my Lord, foremost, the impeachment charges as drawn in the impeachment motion. You can see the impeachment motion, my Lord, on pages 94 to 121 of our next charge, JK1 to JK40. That's bundle, my Lord.
Yes. Pages?
Pages 94 to 121. This is the impeachment motion, my Lord, that went to the Senate. And not the earlier one, the page 15.
Yes.
My Lord, the impeachment motion, if you read, for instance, the first count, that is count number, gross violation of the Constitution. The test, my Lord, is whether the impeachment motion states with specificity the provisions of the Constitution or the law that have been violated. My Lord, I believe the document speaks for itself. Various provisions of the law have been quoted. If you go, my Lord, to the first allegation on legally revoking the appointment of Virginia, and you turn to the evidence, my Lord.
Yes.
And the evidence, my Lord, is to be found in Annexure JK 41A to B. At pages 918 to 920, my Lord.
Yes.
In fact, all the way from pages 917, my Lord, you will see a letter under the hand
Just a moment. Just a moment.
It is Annexure JK 41A.
Sorry, my paper's fallen. Just a moment. Page 917.
Page 917, page 918, 919 as well, my Lord, and 920 to 922. You will see a letter, my Lord, under the hand of the governor, the petitioner in this matter,
Yes.
revoking the appointment of Virginia as CEO of Meru County Public Service. This is a matter, my Lord, where the petitioner can honestly tell you that there is no direct nexus. It was a matter of collective responsibility. Certainly not. On the next, at page 918, my Lord, you will see the advisory that was given by the chairperson of the Meru County Public Service Board, advising the governor
Yes.
that purported revocation was illegal.
Yes.
And at page 920, my Lord, you see the response by the governor disregarding that advice. And this, my Lord, be said to be a matter of delegated responsibility. My Lord, if you turn to, I think I'll point out just a few, my Lord, in the interest of time. The third allegation on refusing to implement the recommendations of the Assembly.
Yes.
You will see at page 1056 of the same bundle, my Lord.
Yes.
The recommendation by the committee to the governor to remove from office these people who the governor who the committee had found that the governor had used. So, my lord, even in the case of where you say the governor was exercising collective responsibility, at page 1060, my lord, you will see that that report was served on the governor, contrary to what the petitioner's counsel submitted. That letter was served on the chief of staff in the office of the governor, at page 1060, my lord. So can the governor properly say she was not aware, or this matter was not brought to her attention? We submit, my lord, that the petitioner at all times knew
Yes.
Further, my lord, there is an authority, I think I saw it in the petitioner's submissions, the authority on, I think it's a Nigerian authority, on what amounts to a gross violation. And it talks about interference with the functions of other bodies.
Yes.
If I remember correctly, my lord. My lord, when the governor, for instance, at the first allegation, it is illegally revoking the appointment of Virginia without a vote of 75% of women members of the county assembly in usurpation of the powers of the county assembly. Is that not interference, my lord, with the functions of other bodies? If you go to allegation number 4, my lord,
yes,
illegally dismissing Dr. Ntoiti, Paul Mwaki, and others, the operative words, my lord, are in the usurpation of the powers of the appointing authorities. Is this not interference, my lord?
yes,
Article 75 of the Constitution, my lord, on breach of public trust would also come in. I think it's also one of the provisions that was put in Martin Nyaga Wambora. When you retire, my lord, you look at it. In the interest of time, I will not go to that. Breach of Article 75 on public trust is enough to establish, and even Article 10, my lord, it is enough to establish gross violation.
You have 5 minutes.
My lord, on the last issue on public participation, before I yield the floor to my learned colleague, Mr. Alex, Mr. Mbaya, my lord, the county assembly conducted comprehensive, adequate public participation. When you retire, my lord, you will consider the public participation report that I'm holding in my hand. It is a 1344-page document. It is a JK 41E. It contains the public participation report.
How many pages?
1344 pages, my lord.
Yes.
It has several annexures. And as you will note, my lord, this document was equally served upon the governor, but she never responded to that assembly. The public participation report has attendance sheets for the various public participation forums.
Yes.
There are minutes for the meetings, my lord. There are registers and memoranda in support and opposition to the impeachment motion. My lord, the county assembly prepared a public participation schedule, which is on page 2061 to 2062. It was published on the Sunday, on the Daily Nation and the Standard on the 1st of August of 2024. And our public participation schedule, my lord,
Published in the
Standard and Daily Nation of 1st of August 2024. It listed the venues for the public participation meetings that were to be held on 5th of August, that is 4 days ahead. It also provided, my lord, that written submissions would be undelivered to the office of the clerk. It could be sent by a post to the postal address of the county assembly, or sent by email to the email of the county assembly. It was equally published, my lord, on the county assembly website, and persons desiring to see the public impeachment motion will be downloaded from the website. If you turn to the next page, my lord, on page 2063,
yes.
you will see the invoice from the local radio and TV station where they ran an advert for 3 days. My Lord, in summation, the public participation exercise was carried on from the 1st July, when the schedule was posted on the County Assembly website, until 5th of August. There was widespread advertising, my Lord. And the Assembly, my Lord, satisfied the test in facilitating, because the test, my Lord, as we are told by the Supreme Court in the Finance Bill decision, it is somewhere in our submissions, my Lord. The test is whether the county, the legislative body or assembly, facilitated a public participation meeting or public participation exercise, my Lord. You will note that, my Lord, the county assembly employed various modes. And, my Lord, given the strict timelines, the 10 days, because the county assembly has up to 10 days to consider, from approval of the motion to tabling the notice and to the disposal, up to 10 days, my Lord. The county assembly has up to 10 days to consider the motion. But they undertook public participation for 5 days, for half of that period. The public participation exercise, my Lord, was therefore comprehensive, it was adequate, and it met the requisite test, my Lord. On the last, just 2 minutes, my Lord, the issue of fair hearing.
Yes.
The petitioner was responded, who was invited, my Lord, to appear before the assembly by the letter dated at the 1st of August, of July, my Lord, I'm sorry, of July of 2024. It is somewhere in our JK 41 A to B. My Lord, the petitioner did not appear before the assembly.
Yes.
As I've just admitted, she was equally served with the public participation report, to which she never responded to. At the Senate, my Lord, and that is the remit of this court, in reviewing the procedures of the Senate, my Lord, you will note from the answer, there is a hearing program, my Lord, in our documents. We equally have the rules of procedure that was served, the invitation by the Senate to the parties. The petitioner had ample time to make an opening statement, to examine her own witnesses. She appeared personally as a witness. Her counsel had ample opportunity to cross-examine the Assembly's witnesses. Senators had ample opportunity, my Lord, to seek clarifications and indeed to ask questions from parties and their counsel, the respective counsel. The petitioner and the Assembly had 1 hour each, 60 minutes each, to make closing arguments, closing statements. And therefore, my Lord, the petitioner, my Lord, was accorded an ample opportunity to present her case and to poke holes in the Assembly's case before Senate could make its resolution, my Lord. We will take guidance, my Lord, from the decision in Sonko.
Yes, you have 1 minute.
From the decision, we will take guidance, my Lord, from the decision in Sonko on that issue, my Lord. And also on the issue of public participation, my Lord, where the Nairobi County Assembly undertook public participation that was not even as thorough as the one by the County Assembly of Meru. The Supreme Court held, my Lord, found that at paragraph 134, the procedure and the standing order appears to have been meticulously followed. I believe, my Lord, from paragraphs 130
yes,
up to 139, my Lord, the Supreme Court finds that the appellant was afforded ample time and opportunity, my Lord. We will equally be urging you, my Lord, to be persuaded by that binding authority, my Lord, where the Senate and the County Assembly of Nairobi undertook measures that were not as thorough as the ones by the County Assembly of Nairobi.
had scheduled a health break at 4, so let's take 20 minutes and then you can have some time. Can I give you 10 minutes? Okay, I'll give you the 15 minutes. So let's reconvene at, should we take 20 or 30 minutes? Okay, let's take 30 minutes. So we'll reconvene at 16:30 sharp.
Ni Baite TV, Baite FM, 90.1, Kodongi Kwetu.
Nakugurua gukunene Ladies of Destiny neba gukumenyithia 2025 Interdenominational Conference iria bakuthuranirite mucemanio jo munene kuma tariki 27 mweri jwa 2 mwanka tariki 2 mweri jwa 3 mwaka jojo jwa 2025 iria ikathithikira Redeemed Gospel Church Muriri. Reverend Winnie Andrew niwe mwaria munene bagwatanirite na Pastor Phyllis Nyaga nibo bakethira bakiritana antu kire micemanio iji. Micemanio ya rukiri kambagiria thaa 3 na ndagika 10 cia rukiri mwanka thaa 10 cia ugoro. Aria ekuru na aria bethi bakamukira Moritani. Micemanio ya ugoro ikambagiria thaa 1 cia ugoro mwanka thaa 3. Aria revival meetings ni chanto bonde akuru ekuru ana ayuthi na